level when you go in the courtroom, that you can win.
What law is that? I mean, who made that law?
It's precedent in the industry that you give the notice. You can't just write one ticket and something.
I just don't think that, we keep saying that we're gonna look at it and we hear you, but I don't think we hear you. And I for one, like I said, I wanna make sure that at our next meeting, this discussion continues to look for, Michael's gonna be short in his office as it is, and we need to get an enforcement officer there, just to keep stringing it on.
When we talk about enforcement, in my mind at least, the objective is compliance. Okay?
Sure.
It's not collecting tickets.
Sure.
It's not escalating it to a misdemeanor or sending an attorney a piece of paper that says, you've got to do this, and he has to tell his client. If you can get there with a phone call or a visit from a uniformed officer and get what you need, you're there, you've got compliance. It's not about just writing tickets or collecting fines.
It's not the punitive.
Right,
It's not the punitive.
objective reality is compliance. That's the goal.
Rich?
And that's exactly, I guess, where I like, the way I like to hear, because I hear right here that there's over 400 citizens they want to put under a ticket. You just told me there's over 400 violate, I mean,
Compliance.
that's not a ticket, that's called coming into compliance, that's the 3 strikes off.
But the problem is, there's 400 out there that we know of, that if we could give a letter to
get that,
them,
but my
to put
point,
them on.
where I'm going with that, Mr. Freeze, is I'm okay with it, because I'm undercovered under the city though, and I already get my phone calls from the new guy that I, it's what you guys are gonna have to put up with out there.
So it'll be a discussion in the board, how and why.
Yeah, and to what level, and we certainly need, we hear, and I agree, and we get the title thing, I caution making it harder enough on our citizens, trying to, because you could go up there, show up there, and you could go, and like you said, if it was a criminal offense, that guy could have been on probation or something, end up in jail over,
I'm not advocating going
over a zoning issue.
prosecution, I'm just advocating somebody
Sure.
that can send a letter out or make the phone call that says, you're not in compliance, here's what you gotta do.
Right.
And then you send them a letter if they don't do it. And then you send them a second letter.
And I
But
think
you
we
got
all
no
agree to
time
that.
make the phone call.
And warn them, yeah, that's correct.
In all honesty, if I might, Chairman, in all honesty, a lot of times a letter, people will become compliant. The city just hired a new zoning enforcement officer.
Well, I'm good, my phone's ringing up from my constituents, but that's the city.
Right, and he's a example is the city is getting cleaned up. And I hate to say it that way, but the city is getting cleaned up, they are. And a lot of times it's just, he stops by, I watched him the other day, stopped in a guy's driveway, and next thing you know, he's knocking on the door, he's talking to the guy. 2 days later, the car was moved. It was a blight issue, the car was moved. That's what we're looking for, is somebody that can just go out and enforce what we've put in place. And a lot of times that letter is all it takes. But, another question, and I approached the board is, and it's okay, my son does trucking. My son is averaging 3 containers a week coming into Cheboygan County. My question is, do you guys want storage containers in the county or not? He's averaging 3 containers a week coming into Cheboygan County, that's one guy trucking. If you go out on 23, there's a guy that's got 20 of them sitting there. If you go up to Mackinac, there's a very, very clear zoning violation that there's over 100 of them sitting there. They're stacked too high, and he's got Mexicans or Jamaicans jumping in and out of the second story. If you guys want them in the county, so be it, I don't have an issue with it. I know a lot of our lakes and stream, that those houses don't want one sitting in the house next to them. Go buy a temporary building and set it there and actually fasten it to the ground where it can be taxed. A temporary storage building or a container can't be taxed in your guys' situation. But I, as a person, and I know Chuck would, and I know Mike would, like direction on these square metal shipping containers. And the only reason I asked for direction on that is because the number of them that are in our county, and I personally know the number of them that are coming into our county on a weekly basis. Like I say, my son's only one shipper, and he's averaging 3 a week coming into Cheboygan County. And I'm just asking for direction. You guys take it up on your own time. We don't need to talk about it today.
Thank you.
I'd like to add one thing real quick.
Hang on, please.
Okay.
Yeah, I think that's a really important comment on the storage containers. They're going in everywhere, they're not getting permits, they go next to somebody's yard, they've got paints on them that are toxic and hazardous. And I don't think we want to eliminate those like Burke Township said they prohibit them in all zones. I think we need those on construction sites and commercials and industrial places until they get their buildings done or whatever. But they just have them spread with no control. That's one man bringing 3 in a week. You have 4 or 5 people like that, they're cheap, they're $1,500 to $2,000 bucks, they're everywhere, they're going in. You see them going down the road, I know, he looks at them, we see them, and we gotta have some support or regulation so we can at least regulate those. It's a big issue.
Thank you.
I was just gonna say, we talked about this at our last planning meeting, and I didn't even think about it, you know? But after we talked about it, I was just driving around doing my daily, weekly stuff, I couldn't believe how many I saw, you know, after we had talked about it, so they're there.
Thank you. Joe, did you wanna?
I think she had her hand up, sir.
Right there. Oh, you left.
Dawn.
Oh, Dawn.
I just wanted to add, most of you know, I retired from General Motors Global Purchasing. Those shipping containers were required to be inspected on a regular basis, and if they had peeling paint, they had to be refurbished before they could go back out again. We're not doing that here. We're just setting them next to people's houses.
Can we control paint?
Well, if it's
Anyway, thank you, that's it.
Staff can get some information together, keep that kind of a summary conversation where to regulate under the ordinance, you're regulating structures or uses, okay? So, a township under the blight ordinance or maybe some other type of ordinance can exercise more, under that ordinance, we can as a county. I'm pretty sure when we have the legal, do the research for that, you're gonna come back and state that you can regulate the use. The structure is a structure, so I guess what I'm saying there is if the container's in somebody's backyard, most likely under general land use provision, there won't be the difference between a shed and a storage container under construction code or under zoning code. Now, if you have some kind of blight ordinance or something like that, and maybe there's a township out there that's pressing that, but we will have to have a legal give us a recommendation, but based on experience, you can't regulate what the structure looks like. You can regulate setback, you can regulate height, you can regulate square footage. If it falls under construction code, you can regulate whether it has a footing or not. You can't regulate paint under some.
I'm sorry, it was toxic, that's the reason.
Yeah, that may be a state issue, but it's not a land use issue that we have authority as a county. Maybe the state of Michigan has regulations for that, but that'd be up to the state of Michigan to enforce it. So the other is, if there's 20 containers sitting on a property, they either have to be tied back to personal use, and tied back to that use, or it's a contractor's yard, or it's a storage yard. So if we have a bunch of storage yards out there, then those are regulated under use, and those should be approved. Those can be looked at, but it may be very difficult to regulate if somebody has it on their property and it meets all the setbacks and height requirements at the end of the day, so.
Just 1 second. If it's a structure, they still have to come in and get a zoning permit, the
Yeah.
distance from the property line, the height, all those things, but none of that's happening now. So even if we get direction to get with some regulation, I'm happy with it. Go ahead, didn't want to take your time.
I would just like to, if we do, I do that, I agree with that, but have a more public hearing though on that, because I would like to hear other parts of these people, the people that are regulating, what kind of hardship, or may not will help us regulate, just to blanket it and stop it.
Yeah, we don't want to.
Well, I don't think that's the intent, but it's pretty easy, as Jeff said, if there's too many containers, it's becoming a storage yard. And I agree that, and I think you're looking for, I believe that we would like to see some container restriction. Is that, I mean, would that, think the commissioners, I mean, to answer your question, I think that is the direction, but again, just, especially if there's use for them in, told, like, my yard, you know,
Exactly.
you know, where they didn't get it.
I know one property in the city, because I permitted it, that has a storage container, it's over 192 square feet. So they had to get a building permit from the county to put it in. And they put it on a concrete slab, and it's got a door on it. And it looks nice, it's painted white, it looks okay, but like Jeff said, you can't not permit it. It meets all the setback regulations, it meets the building code regulations, and it is taxed.
No, it all circles back to enforcement though, because we've had comparatively few zoning permit applications for the placement of storage containers for personal use. However, from what I'm hearing, the county is receiving numbers of these on a weekly basis. Several of you have indicated that we have dozens of these out there already. We haven't seen any zoning permits for any of them. So, again, this conversation circles back to enforcement.
Okay, we're ready to hear from Joe.
I don't want to interrupt. This is good stuff. We can take something from Lord of the Rings and have constables in every district do this. But anyway, I was asked by the planning and zoning folks, some of them, to come in and try and shed some light on how we got here. I know that you were here, but there's only very few people that really know the story of how this happened, of how we got to the solar into the Lake Stream and Ag Forest. But what happened is, back in 2017, 2018, the same group of people that are approaching us again now, which would be MSU, U of M, and that whole cabal, they came in and convinced a naive or uneducated planning and zoning team, which was prevalent throughout the whole state. Nobody knew anything about solar or renewables. Nobody knew anything. But if you follow the money of these people that are on this list that provided all this training across the state, including Ms. Kaufman, you're going to find that they said the same thing to everybody and said, look, why don't you just do a textual amendment? You can just write it in and approve it wherever you have property. In our case, it was Ag Forest and Lake and Stream. That's what happened with Orion. Orion came in with MSU, the extension office, if you remember. I have all the meeting minutes. I've been reading tens of thousands of pages, and it is boring. But I have a lot of the meeting minutes and stuff that show what happened and how this happened. Now, we can look back with hindsight and say, it's a shame we don't know back then what we know now, or this never would have happened. Okay. Because of that, what they did is they made solar an authorized use in those two districts. Okay? They made it an authorized use. According to the NZEA, if it's not an authorized use, and called out in your ordinance, they're not allowed to be there. They knew that, and they convinced the county at the time to make it an authorized use in those two districts. That opened the floodgates. You just have to be thankful that no other business came in and wanted to do the same thing, because you could never have denied them, even if it was a hydrochloric acid factory. They could have come into a Lake and Stream or Ag Forest and put it up, and you could not have denied them. So be thankful that that did not happen. Okay, your moratorium is in place right now, and we have to make progress, just incremental progress over these months. Okay, that's what the moratorium is for. I understand what you wanna do with the overlay, and I think that's an incredible idea. However, if you don't go back and fix your ordinance and put it back to where it was supposed to be, then all of this other stuff doesn't matter. So what I have proposed is that we go back and do a partial repeal of 150 and get these green renewable projects back out of those two districts because they don't belong there. However, we have no problem with putting these in industrial, light industrial, commercial, and those districts because that's where they belong. It's not our fault that we don't have large tracts of land in those districts. We're not Detroit. We're not Grand Rapids. We don't have that up here. That's not our industry. Our industry is ag, forest, and recreation, lake and stream. That's what our industry is. So we are not under any obligation to make allowances to expand these zones that are already in place. They're in place for a reason. Okay? And we've done a phenomenal job, Mr. Freeds especially, creating this ordinance back in the day. I've read so many ordinances across the state, and ours is incredible. The way he wrote it was great, under a big time constriction at the time. They said, oh, you have to do this right away. And to do what you did in that short of a time frame is just remarkable. Now, these people that from MSU and U of M and all these people that are making all this money on all these, you all have this. You already have this, okay? Look at the list. What they did is they took that 2018 presentation, made a couple of quick changes to it to include 233 in it, put a new date on it, said 2025, and it's identical to the one that were hoodwinked with back in 2018. The problem with that is that as I'm reading through, you have the newest one actually in your packet today. What I'm being told is that now we want to go and rewrite our ordinance to match what MSU and U of M and all the energy companies and all their attorneys are telling us how to rewrite it. That it's incorrect. We cannot follow that same path. We did it in 2018 and look what happened. They want us to do it again now. For example, as you pointed out earlier, the whole idea of planning and zoning through the MZEA is to regulate land use. One of the things that MSU says, oh no, just tell them you want to regulate megawatts. Well, that has nothing to do with land use. And it goes against our current regulations that we already have in place that deals with that. We have an incredible ordinance. It needs a little bit of tweaking, big deal. What you'll find out is when you open up the book, and I've got the ordinance book if you want to see it, section number 5 is blank for future use. You want to create another overlay district, pop it in 5. Pop it in 5. But before you do that, you have to fix the districts and go back and fix the error that was done in 2018. Okay? You got to do it. Otherwise, your overlay is meaningless. They can still come back and fight it. And the veiled threat of going to the MPSC, let them. There are 10 projects there and 0 have been approved because the state doesn't want to clean them up. I've got, now Samir, this isn't against you, but I've got his estimate from Atwell, and they said, oh yeah, it's only going to cost us $5 million 35 years from now to clean this up. The project is $300 million to install, but $5 million will cover it. Come on, that's crazy. It's just, you're getting the information from them without a certified third party who's neutral to come in and make these engineering decisions for you. Okay? You're simply, and that's what happened. We simply relied upon their 5-inch binder, went up against our 5-inch binder, and the judge said, no, you're right, they didn't follow the rules. No, and that's really what happened. That's why the permit was vacated. So what I'm suggesting is that we go back and we get rid of those sections of 150, which I've passed this out before, and I have a couple more copies if you want. Just to go back and reset the ordinance back where it was in 2018, and follow what the master plan says. Okay, the master plan was made at that time for that reason. Okay, but they figured out a way to get around the master plan with textual amendment, instead of forcing these people to go through the long, drawn-out process of asking for a rezoning. We'll just sneak it in with a text amendment. That's called spot zoning. It's a quasi-legal process. Okay, we can't make that mistake. And not only that, we have to go back and fix it. We have to put the integrity of our zoning ordinance back where it's supposed to be. And I've offered my services, and I'm open at any time. I've done nothing but research this since day one, since I met that young man. And I've offered my services, and I have everything. There's nothing secret. I speak all over the state about this. I've written white papers. I've got a way that we can track every one of these using manufacturing processes. There's a way to track every panel till from the time you put it in to the time it goes in the brave, to make sure that we're getting the tracking, okay? And we're following these things, that they're not just ending up in our landfill that's going to ruin our environment.
Thank you, Joe. I've got to open it up.
I know.
Thank you.
All right. So
Anyone
you're
else
up.
like to talk to the board?
Mr. Chairman, can I speak for
Okay,
2 minutes? Samir Jan, I'm with EDP Renewables.
Hey,
North-
Samir.
Yep, hi. And we are the ones who are managing the Northern Waters Solar Park down in Grant Township. So I've had the pleasure of coming to Cheboygan County for 3 years now and getting to know a lot of the different departments here. Again, working with the Planning Commission on the approval last year. Obviously, that permit was vacated by the judge, but it's still under litigation in the Court of Appeals, so won't comment directly on that, but just wanted to talk from a developer's perspective and appreciate you all sitting down and having this discussion. Just wanted to hit on a few things that were brought up and maybe shed some light, just working with different communities around Michigan, Ohio, Indiana. So one of the questions that came up was about the entities selling projects in the future, whether it's during development or during operations, but anything that was associated with that permit that was approved or any agreements that were signed would directly get passed on to whoever that developer is. So they have to remain in full compliance with anything that was met, any sort of economic development agreement, all of that. A lot of questions about decommissioning. So first and foremost, when working with landowners, speaking from my experience, they're going to want some protections in there about the company being responsible for decommissioning at the end of the project's life. So that's typically the first layer of protection you have in there. And then in a county ordinance, there will often be the requirement that was brought up today about posting a decommissioning bond in the case the company were not to fulfill their obligations at the end of the life. Another thing that EDPR proposes, I don't know if every developer does, but a decommissioning agreement directly between the county and the developer, stating the obligations of whatever that performance bond may be, a third-party engineer agreed upon by both the county and the developer to provide the estimate of how much it would cost to decommission. That's, again, refreshed every 5 years. So a lot of that is spelled out in that agreement and is buttoned up prior to construction. One other thing I did want to talk about is the idea of the overlay or restricting in lake and stream protection or ag and forestry management. Again, it was brought up today, the proximity to the transmission line is key for these large-scale renewable energy projects. You don't want to have to build additional transmission all the way through when there's already a line there that has capacity on it. Again, when looking at Cheboygan County and looking at the GIS, there would not be enough industrial land to serve one of these utility